Welcome, everyone, and welcome Cathryn Reher, who is a um, lawyer, an elder law attorney, and helps people figure out all of the paperwork. And we send a lot of people because, believe me, I don't know what to tell people. So that's why we call in the experts. And she generously offered to talk to folks today about how planning can really be helpful to you. So with that, I'm going to mute myself and turn it over to Cathryn.
Well, good afternoon. It's a pleasure to be with you all. This is a format that's harder for me because I like to be with people in person. I usually like to be up walking around and gesticulating when I do presentations. So being in a very confined space is more difficult, but I really appreciate the opportunity to be here today to tell you a bit about what I know. So I'm a shareholder in the firm of Reher, Hanson Price, and we work out of St. Louis Park. And I've been doing this for almost 30 years now. And what it is that I do is I do elder law and special needs planning. So back in the day when I first started, it was predominantly just elder law. So working with the elderly population and addressing their transition into long-term services and supports. But what happened in that process is that we kept finding there were younger and younger people that needed our help to navigate government benefits and also how to just manage their estates when they were getting a diagnosis that they knew was going to come with a financial consequence. And so over the years, I've had a lot of varied clients with varied backgrounds and needs. And we just try to service people to answer their questions and help them feel like they have support in their journey. So Lynn, I'm just going to ask you, what did you think you were coming to see me about? And what did it actually end up being?
So as the bomb dropped kind of on the diagnosis, and I'm 52 years old, and had in a vibrant career that I love. When the diagnosis came, and it became clear that we wrote our estate plans when our firstborn was born over 20 years ago, and hadn't really looked at him in a long time, and hadn't really thought we would need some of this help. It was really, we felt like we were in the deep end of the pool, trying to figure out what did we need for estate planning documents. That's really what I thought. And then where the conversation led was to, did you know about this program? And did you know, hey, we've worked with people with ALS in the past, and it could look like this and it could look like that. And you could change your mind, and all of these variables and all of these possibilities that were laid out by Cathryn through our conversations that made me feel more empowered. Both Gino and I, we felt way more in control of the situation that really is kind of out of control. And we also felt a lot more informed about all of the various supports that can be out there depending on our situations. And so kind of that possibility thinking became a real buoy of hope for us as we began to navigate what we could do in our planning.
And I really appreciate that. I think that the thing that is missed so often when you go to an estate planner, and what distinguishes us from an estate planner, and the idea is that if you're doing estate planning, you're trying to make sure from a tax perspective that the estate is sorted. And then you're trying to figure out, well, how do you pass wealth after you die? And really the difference for me as a planner is that I'm much more focused on what's going to happen to you during your lifetime. What are your goals? What are your ambitions? What do you want to do with the time that you have left? How does that translate into how you would lead your life? Because nobody knows if you're going to live to tomorrow. So the diagnosis just helps to focus our energies on something we should have been focusing on for a long time. And so with that goal in mind, we also know that to do a good estate planning means that for somebody who has a diagnosis, or a caretaker who's living with somebody who has a diagnosis, that we're looking at what's going to change in our life. What's going to need to change? And how are we going to best address that? So the place that I do a lot of planning is around what are the financial changes that are going to happen during that process. Do you understand your assets? Do you know how to liquidate them? Do you realize what the taxes or penalties might be associated with that? Are there better ways to pay for care? What are the range of options to pay for care? Who's going to provide that care for you? What are your resources in the community to have those appropriate supports? If you're what we call a solo these days, that means somebody that doesn't have a ready base of support. Who's going to be your advocate? Who's going to be there to step in, knowing your diagnosis and the types of supports you're going to need over time? So even though we do estate planning, we are much more rounded towards how do we take care of somebody while they're alive? And what's that transition going to look like when they're needing more advocacy or more supports? And then are the right powers in place to help as that transition is occurring? So I think that all of us know in life, because this group is on the more mature end of life, that we're more aware that what you think you're planning for may not be what happens. And it just keeps happening that way, that we go through life and we keep getting hit from different sides with different priorities, with changes in circumstances, with things that we couldn't anticipate. So for me as a planner, what I'm trying to do is to be the person who anticipates, because I work with so many different situations that I know what could happen that is out here on the periphery that isn't being thought about, the person that either got the diagnosis or the person who's the caretaker. So Lynn, I don't know if you have any follow-up thoughts on some of the things that I just brought up.
Yeah, I just would offer that one of the things I appreciated a lot in our first conversation when I was all in this tax planning mode, after having spoken with another attorney, is how carefully and thoughtfully the questions were just about like, yes, and what about, what are the things that are important to you that you want to make sure stay in place, that had nothing to do with documents? It was like, for example, if you never want your feet to be cold, how do we make sure we put something in place that happens for you? Or if I have 3 sons, Gino and I have 3 boys, and if you want to make sure that when they enter the room, that they always greet you, how do we make sure some of those things get captured and documented? And that's way outside of what we typically think about estate planning, but it made us both feel so, again, just comforted, and like we really did have a bigger, broader plan that was going to serve our family really, really well. And I also appreciated the nudges Cathryn offered around legacy. So she mentioned this notion around how do you want to live these days? How do we make these our best days? Some really good, careful nudges around legacy work as well that helped us get thinking in ways that, again, felt more positive than just doomsday.
Right. Because I don't believe that what you have is a problem, right? A diagnosis is not the problem. It's how are you going to lead your life with the life that you have? And then knowing that you have a diagnosis, how are you going to make sure that the people that you empower to assist you are going to carry out those wishes in a way that are respectful, that are well known, so that if you're having more difficulty articulating for yourself what it is that you would want to have happen, that there's somebody there who already knows. So we are not interested, if possible, in crisis planning, which is what a lot of planning is for people to get a significant medical diagnosis. And we want to change that around to life planning, to being more thoughtful and considerate to what do I want my future to look like? How am I going to make that happen? And who's going to be a part of my team to make that happen? So I think that that's maybe all a little bit more nebulous. It's more intangibles that we as attorneys working with people that have significant medical diagnoses, that they have a place where they can go, that we understand the medical issues, we know what the prognosis is probably going to look like, we know what kinds of supports are going to be needed, and we're trying to formulate a plan around that, not just deal with taxes, or, putting some form documents together that really don't even begin to meet the needs of the individual. So maybe that helps you a little bit kind of understand what's possible in planning. When we talk about forms, the types of forms that we're talking about are legal tools that can assist you through life and after death. And so those tools, most commonly, you probably have already heard of these, are powers of attorney for managing finances, health care directives to help manage the advocacy and care coordination, possibly trusts that could be helping to manage resources while you're alive or after you die, and possibly wills that could be expressive of intentions of where your estate should go after death. But there's so many more types of legal tools, and those legal tools have been developed over time where the state of Minnesota has determined that there's a need and maybe somebody didn't plan ahead of time. So we have legal tools that way in case the right plans haven't been put in place to be able to manage things. So we have legal tools to help us. And part of my job in doing estate planning is to help you figure out for your goals and your needs, what are the appropriate powers to put in place? Who are the appropriate people to help carry out those powers? And then we have a whole nother piece of the type of planning that is usually needed for somebody who has a significant medical diagnosis. And that is the potential of understanding long-term services and supports. So those activities of daily living that you may need assistance with, the need for transportation, possibly a change in your living arrangement as to where you get services provided. And it's my job doing elder law and special needs planning to understand what those environments are, how they work legally, how they work in relation to government benefits. And if you don't want to be in one of those alternative environments, how would you bring services into your home? And what would that look like? And what would it take? And getting that information to you well in advance of your progressing to that point so that you have the ability to decide, if this happens, this is when I'm going to transition, this is where I'm going to transition, and this is how it's going to happen. And this is who's going to help me in that transition, so that everything is moving upstream so that it feels less like chaos and much more as if it's planned, because there's plenty of chaos that none of us control. So the point is that in the midst of that, what we want to try to do is to build in structure for the things that we can manage. And I also think that that when you know what the worst thing is that can happen, it gives you time to manage it, to put it in its place, to grieve or to prepare, whatever that might be. So when I work with people that are trying to manage their situation financially, or maybe they're worried about their child, or they're trying to figure out what they're going to do, is we want to identify that worst case scenario and have a plan, even though it might not feel very good. And even though it might be really hard, that we still have a plan for it. And that you know what things you can't control and what things are going to be bad that are going to happen. And we're going to figure out how to keep going through it. So I know that perhaps some of you want more concrete information, and I'm going to move into that. I'm going to go back to Lynn, though. Any other comments that come up to you in relation to that?
No, I would just confirm that for us, that was the case, where we had all these scary things in our head. And when we started naming them and putting them sort of out there as scenarios, it became much more like, okay, you know what, if that's the worst thing that can happen, and we feel like we've got some scenarios that we've jointly built, it may never come to that. But if it does, we've said it out loud, we've put it down on paper. So it did really help us to sort of exhale a little bit. And I also appreciated how much we've got these 3 boys, and I appreciated how much Cathryn just brought them into the picture to say, you know, what about this and what about that? So that it wasn't just Lynn and her disease. It was this, here's our family, we're really connected, and how does everybody kind of work together? She asked about my parents, my sisters. I mean, so just really the bigger picture, that was super helpful and felt proactive.
I think that one of the things that I see, and I invite you to think about this, is how hard it is if you are the person who didn't get the diagnosis to feel that you can come in and ask questions, to feel like you're not violating the person who's had the diagnosis, to not know how to go into conversation with things that are hard. And I think that that inviting the conversation, if you're the person that has the diagnosis, and to invite them in and say, I know that you're probably concerned about these things, and I want you to feel that you can come to me and talk to me about it. And trying to have a more open dialogue, or a place where you can have a dialogue. And for me to give you some of the words to be able to initiate that discussion, in order to find out how they really feel about things. And sometimes some of those discussions can be hard because they may not have the same idea as you about what they want your future to look like. And so I think that having some of those dialogues can be helpful for you to better know who should have the powers, who should be your agents, and do you limit some of those abilities to act, or do you know that you've got somebody there who's just going to be a wonderful resource for being your advocate in a time of need, if there is a need. So to kind of summarize, what we're trying to do is to understand your medical diagnosis, and that is a financial diagnosis, that we're going to use our understanding of government benefits when we do your estate planning. So if we identify in looking at your financial future that you could qualify for a government benefit, or we don't want your spouse to become impoverished in the course of you paying for care, that we're going to try to identify the places where we could dovetail into a government program and build that into the powers that your caretakers or your advocates have. We're going to look, one of the things that was interesting with Lynn's situation is she was still working. And a lot of times we're trying to figure out employer insurance, to figure out what's going to happen in moving through COBRA, or trying to move off of employment into Social Security disability if you've got a long-term disability policy, reviewing contracts that might be coming up. Lynn, do you want to share anything about that experience?
I would. And again, one of those things when you get your at work, if you've worked in a place where you get these benefits, you kind of look at them and breeze over them because you don't think it applies to you until it applies to you.
Yeah.
And so I quickly went to like what was on page 17 about, you know, disability insurance, et cetera, and flipped through the policy and realized I didn't understand it at all. And so scheduled a call with the HR person at my employer, Cathryn, the Mutual of Omaha representative, who, you know, is the representative of the disability benefits. And they made sense out of what to me was a little bit of Greek. You know, it did not, they netted out quickly for me. This is what it means. This is what it means for you. This is how it will work. This is how it could work. And so again, having Cathryn as part of, she really led the conversation and exposed some opportunities for me to do, again, instead of feeling scared, I was able to feel like, oh, okay, now we have a plan, and now I know what makes the most sense. And I'm still working, and I'm moving towards disability sometime this summer, but I feel like I have a plan, and it's actually more proactive again, where I don't feel scared of it. And even if the timing, we had different scenarios of timing, if this, then this, and if this, then this, but you know, we kind of talked through all of the different possibilities.
Yeah, and I think that it's one of those few times where we cannot be adversaries with the attorneys for the employer, where what we're all doing is saying, you know, this diagnosis has occurred. We need to figure out the timing. We need to figure out the transition. We need to know what benefits are there, how we access them, when they're going to come up. It's, you know, there's a fair amount of benefit coordination going on for people that are still working and have gotten this diagnosis. And I think it's something to, as soon as you can, if you have a supportive employer, move that way. If you don't have a supportive employer, then you have to work very covertly to get things in place before you notify them. So all of us are in different situations that way. The other thing about working with a team is we're really trying to figure out how to support you on good nutrition, mental health supports, community-based resources, care caregiver support systems, what are going to be some of the triggers that we know you need better supports, and other professionals that are going to need to be on your team. So very important in planning is having a good CPA, somebody who can run the tax issues with us as we're looking at plans and what the tax consequences of those plans might be. And so part of that process, and your financial advisor is going, okay, this has been the history of what you've built financially. What are the implications of if you have an annuity and you have penalties, or you're going to have an employer-driven pension coming due? You know, how do all these pieces fit together, and what type of information are we going to need if you're going to need to move on to a government program to help pay for some of those costs that you might incur over time? So I know that I'm going to talk a little bit about legal planning tools, because I know that most of you have some familiarity with those different tools. But what I want to point out is maybe what you're not as aware of, and I'd like you to go back and check your existing tools to see whether they're going to meet your future needs. So the first one I'm going to talk about is probably the most well-known one, which is called a power of attorney. And the use of that power of attorney, most people think about it as, I want somebody to pay my bills. I want somebody to be able to get my check deposited. I want somebody to be able to claim the insurance that I'm supposed to be getting. So some pretty basic things, or I need somebody to help me get my house sold. Those are things that a power of attorney can do. But what I need them to do when I'm working on disability planning is much bigger than what a standard power of attorney would do. So I'm going to just walk through a few pieces, because of the limited time that we have, about powers of attorney, but things that I want to highlight. So one of the things that I notice a lot is that people will have maybe 2 agents. So they might have a spouse and they might have a child. And unfortunately, I'm the person who says, what if your spouse dies before you? What if your spouse ends up incapacitated? Now we're down to 1 person. That's not good, because if that other 1 person isn't available or is stuck with all that responsibility to manage those various pieces of the puzzle, that can be very overwhelming. So one of the things that I'd like you to do is to ask yourself, do I have depth in my plan? Number 2, if you haven't looked at your documents in quite a while, look at them, because they're kind of critical. And it's important that you know who you have managing your finances and whether they're really going to be able to carry out that duty, and whether you have enough people on your team to do that. There's a lot of financial abuse with using powers of attorney, and it is a reality, and it's a scary one. So the biggest lesson I can give you there is no way to protect against the unexpected abuse, that somebody who goes rogue on you that you never could have anticipated, that nobody can plan against. Then you give up all the benefits if you don't plan to have a power of attorney in place, and to have that flexibility and privacy, and have things set forth for you as to how things are going to be managed. But if you have somebody that you know has a character defect and they shouldn't be managing your money, then you don't put them on just because you don't want Johnny to feel bad that the other 2 are included and you left one off. This is about really needing somebody that is impeccably trustworthy, and I say less informed maybe necessarily about doing the job, because they can always get professional advice on how to carry out their responsibilities. But trustworthiness is really important. So we have depth, having enough people that are going to be on your team to manage the financial issues that you might have, making sure that you have the right people that you can trust implicitly with those responsibilities. There are many, many ways that you can set up the powers. So there are a host of powers that are available. And I'm going to tell you right now that the statutory short form power of attorney in 95% of the cases that I work with my clients is insufficient, because it doesn't have enough powers or the right kind of powers to do disability planning. But I love the short form power of attorney, the one that most people have, because it has some pretty good basic powers in it. And I don't want to lose those basic powers, but I want to add to it. So another area for you to go back to is, what powers did I extend? Are they the right powers? I'm going to tell you some places where the short form power of attorney that most people do does not contain powers that I need in disability planning. So there are certain types of Medicaid-based trusts that I set up routinely for my clients that have do disability planning and are likely to go on to Medicaid or other government programs. So those trust powers are completely missing. There are no trust powers under a short form power of attorney. So if I need to set up one either for the person with the diagnosis, meaning the principal, or I need to set one up for their child who might have a disability, those types of powers are not in the short form. There are no powers in the short form to add a beneficiary to an asset that you have. So let's say that you had a CD mature and you needed to reinvest it somewhere else. And the place that you needed it reinvested, they needed to add beneficiary arrangements so that it would pass at death. There's nothing under a short form that permits that. There is a beneficiary power, but that means that when the principal is a beneficiary of somebody else's estate, that your principal would be able to extend powers to somebody. But under a short form, those powers are again missing. Another area that we're all becoming intimately familiar with is what we call digital resources. And the federal laws governing digital resources predates the internet. And we do not have state or federal laws that are well defined that enable somebody to come in and deal with your electronic records. And so we do include digital resources as an additional power beyond what you're going to get in a short form. So there are a lot of powers that I need to do good planning for you that are not in the short form. And so when you're working with somebody who does elder law, they're going to be in a better position to evaluate for what your goals are, for what your needs are going to be. Do you have the right powers in place to have that carried out during your lifetime? Let me see what else I might want to say on this. So I think that a lot of people also, if you are married, I want to highlight that just because you're married does not mean that your spouse has the ability to manage your individual assets. And on top of that, that they are going to need the right powers to be able to access your individually owned resources. And a lot of spouses have been either told improperly or misunderstood that when they got married that their spouse would have rights in their estate or could just step in, and it is absolutely wrong. I have as much power as your spouse does to manage your separate resources. So we run into problems with the short form that there's not enough power. For instance, a lot of times in planning that I do, I want to move a home from the ill spouse to the well spouse as a means to protect the equity in that home. And if all between the spouses that you have is a short form, the maximum power annually that can be transferred under that form is $15,000 a year, even if you're the spouse. If you exceed that power as the spouse, you're violating the law. So I think that that's about as much as I have time to say when we're looking at financial powers of attorney. But they can be a powerhouse for you if they're set up right. And they can be incredibly limiting in my ability to help do planning if they're not set up correctly. So I think it's a good time for you to maybe go back and rethink, why did I do this? Did anybody really ask me these types of questions, and did it get set up correctly? Do you have anything else, Lynn, that you'd like to add?
I just would add that since Gino and I, neither of us are attorneys, because a lot of it doesn't make sense to me still.
Yep.
We would talk through it in scenarios like, what if this happened? And then what do you mean by that? And the way that, again, Cathryn explained it to say, like, it could look like this. And what would you want to have happen if this happened in a scenario instead of in legal language that, again, didn't make sense. And even some of what you just described, I mean, did we do all that? I don't even know. It's by her kind of knowing all of the technical, but boiling it down to the sort of personal, really made it, because the good news was we did have answers. We did kind of know we would walk through this door, not that door, like if she painted the picture. And that was just really, really helpful.
Okay. So if you don't have enough power, the right kind of power, you haven't done planning with regard to who could step in to assist with your estate from a financial standpoint, there is a court process called a conservatorship. And one of the things I would just warn you on is there are a lot of medical providers who will tell you, either as the caregiver or the person with the diagnosis, you need a guardianship and conservatorship. So many times I have had individuals told that, and they absolutely did not need that. And they went down a completely wrong path and made things much more complicated, expensive, and so many pieces were unnecessary to their planning because they didn't understand what they were asking for. They were told something by a provider and they just went ahead and said, I guess I need this. And nobody stopped to say, well, do you? Do you have the ability to, even though you might have limited speech, that doesn't mean you're not in there and you're not somebody who should be disregarded. What do you want? Can you communicate it? How can we help you? How can we assist you to get the right powers into place without having to go to court? So it's not always appropriate to avoid court if somebody truly has lost capacity and did no planning. There's a mechanism called a conservatorship where we can petition a court to get somebody appointed to be able to assist you. But here's the real downside. It costs a lot of money. It's very expensive. Most of the times, the courts will also require that all assets that you have go under bond, which means that the person who's going to be appointed has to have a bond against potential loss due to their malfeasance, even though they might be completely trustworthy. The cost of that bond is very high on an annual basis. The other thing is that you lose flexibility in planning. And what we find is that I've gone in on a petition between a husband and wife where the husband lost capacity and they hadn't done their planning ahead of time with joint certificates of deposits. And I wanted to cash out the joint CDs so that the wife would have some cash. The court refused. And they don't have to explain themselves. So when you get into court, you lose control, you lose flexibility, but you get a protection from the court against loss. So if you really don't have anybody that you can trust, you could set up a voluntary conservatorship to make sure you were under court supervision, or maybe to protect you from somebody who was very violent or inappropriate and needed to be kept away from you. So that is the other tool that we have for managing the estate. People that are living in different states. So I understand that this chapter incorporates other states as well. I'm giving you basic information that should have application in most states. So just so that you're aware of that. Okay, so in the state of Minnesota, this is not true in all states, but in the state of Minnesota, we distinguish between who has the ability to manage your estate, who has the ability to get access to financial information or information from an employer. So somebody who's able to manage your estate is not a person who can manage your person to make decisions about what medical care you get, where you get it, what treatments to start or stop. Which doctors to go to, where to get that care, and after death to decide about organ donation and then disposition of your remains or your body after death. So those powers are specifically set up in Minnesota separate from who can manage your estate. The main thing I want to highlight to you is that the persons who are most beneficial maybe to manage your estate may be the worst people in the world to be making your medical decisions. And that's why we keep them separate, so that you have the ability to come up with the best team to manage the financial aspects and to manage the healthcare. So there are different types of forms that are available. And I'm just going to give you a very brief background on what the law is that's developed in this area and where it came from. So we started with what was called a living will And that was the ability for somebody to be appointed as your proxy, but only if you were determined to be terminal. So that means less than 6 months to live. And they could only step in if you could not communicate your own desires. Now think about how many medical diagnoses are out there where we need somebody to step in for years to manage complex medical and to be an advocate and to do those things. So the state said, well, that's not enough power. So they sunsetted the living will law and they came up with what was called health care power of attorney. That law extended more powers to somebody you would appoint as your proxy or your agent, but it did not address some of the more dicey issues like mental health. So people were ending up having to go back to court to get psychotropic and neuroleptic drugs and other therapies for people with mental health issues. So then what happened was that the state passed a health care directive law, which is where we are at as a state, so that it's possible for you to kind of write your own instructions if you wanted to about how you want to manage who your agents would be, what powers you would extend to them, under what circumstances, and it can be as simple or as complicated as you might want. So there are many different types of forms out there to assist you, but here's the main thing I want you to hear. A healthcare directive in the state of Minnesota has no application if you are in an emergency. I really want to highlight that. So in the state of Minnesota, the only way that you can have a plan in place before the emergency arises is to have a doctor's order. A doctor's order is either going to be a do not resuscitate, do not intubate order, an emergency resuscitation guideline, or a provider order for life-sustaining treatment called a POLST. So in the state of Minnesota, there are ways for you to put directives in place with your doctor by order prior to the emergency arising. So what is an emergency? An emergency is when you call 911 and they're responding. If you're in the ambulance and you're being taken to the emergency room, if you're in the emergency room and they are stabilizing you, those are emergencies. If you're undergoing a surgical procedure. So most people really don't understand, if they are the healthcare agent, that there's a limit on the powers that they have. So last thing that I'm going to say about powers of attorney and healthcare directives, these are your most important documents. It has nothing to do with whether you have a diagnosis or not. I tell people, if you are 18 years of age or older, every person should have documents that are appropriate. They are not static documents. They're not going to take care of you for the rest of your life. They're intended to look at your team now and who can support and assist you. And as that changes, that you make changes in those documents, because they are by far the most critical. The other thing that I think is a big misconception out there, if you have a financial power of attorney and you have a healthcare directive, at the moment of your death, all powers cease. There are no continuing powers after death except organ donation and funeral arrangements if they were extended in your healthcare directive. So a lot of people don't understand that the persons that they may have appointed to assist them during life do not automatically continue to have those powers after you die. So what are the tools that we have to manage an estate after death? Well, the tools that we have are state laws that can enable a person to step in as your successor in interest and possibly clean up a car title that needs to be transferred, or to be able to file your final tax returns, or to be able to collect a small amount of resources that may have been left over and needed collection. So there are some informal mechanisms that are out there. A lot of people will set up, because they're most familiar, they'll set up a will. A will, if you die with one that is legally enforceable, is going to require a court process A will does not simply direct somebody what to do after your death. It means nothing until it's submitted to a court, approved by the court, and then somebody is appointed to take on the role of administering your estate in a court process. So there's a misconception that if you were naming somebody in your will, that somehow they have power to manage while you're alive and after death. So the person you named in the will to maybe manage your estate, called an executor or a personal representative, is not imbued with any authority until you're dead. Sorry to put it that bluntly, but that is what happens, is at your death. If you have a will, then that will has to be submitted to a court. So for me and my planning, a lot of times we're trying to make sure that the will is only a backup and that we don't have to go to court after death. But occasionally, I am planning an estate to go through a court process for reasons that are articulated by my client, where we look at a situation and we go, we want to be in court after death. But it's really a backup to your other planning. So another point that I want to make is that when you die, your estate goes into two buckets, either what we call a probate bucket or a non-probate bucket. A non-probate bucket is an asset that will automatically flow from your estate to somebody else. Most commonly, we know this as beneficiary arrangements. So if you went and made a list of all of the assets in your estate, would you know where every asset is going to go when you die? If you don't know the answer to that, you need help with your planning. So the way that we pass wealth can be by beneficiary designation. But if you set up beneficiaries on half of your assets or 3/4 of your assets, and you leave other assets without beneficiary arrangements, you could cause great difficulty for the person who's going to have to come in and manage your estate after death, because they may not have the amount of money that they need to manage your estate after death. If you are leaving everything not to be probated, you may lose control that's needed by somebody to administer the estate. So these are the types of things that when you're doing good estate planning, you're trying to figure out what's that transition going to look like from life to death, and how do we make that as smooth as possible, taking into consideration this is where tax issues can come up. This is where family fights can affect the plan, or the needs for somebody who's a minor or incapacitated spouse who might survive you. These are all things that we try to address through not only a will, but through potentially using trusts in very specific circumstances. So I'll tell you just a little bit about trusts, and then I'm going to see if there are questions. So in the area of trusts, I want people to understand that a trust is simply a set of written instructions. Those instructions are intended to assist with the management of assets that are going to be managed by the trust. So we use trusts in many instances where we need assets protected for maybe a spouse that isn't that great about managing their resources, or a child with drug or alcohol issues, or a child with a disability, a child who is a minor. And I also use trusts, which are, again, instructions for persons who need to get on government benefits. And there are many types of trusts, and I don't have time to go through that today. But we look at your estate, and that's what the elder law or special needs planning attorney should be doing, is looking at, are there strategic uses of trusts at various parts in your journey that could better protect assets in relation to qualifying for a government program, or to protect persons in your or affiliated with your estate. And then I think the last thing that I want to briefly mention, let me see if I can bring this up. Well, let me see if I can find that. So what I wanted to explain to you is, for a person who may need help with government benefits, there are many different programs out there that can assist. If you're a veteran, you may have access to VA-based benefits. You may be entitled to care through the Minnesota Veterans Homes. You may have long-term care insurance where you need to make a claim, and there's a Minnesota Partnership Act that may entitle you and or your spouse to retain more in assets and qualify for medical assistance if you have a qualifying policy. There is medical assistance, which there are many, many doors into medical assistance. A lot of individuals think that they're just told by some entry point through the state that they have too much and to go away. And so many times that is not the correct advice to have given. So our job is to evaluate upfront what's the soonest you can qualify for benefits, what's the best way you can protect those assets and qualify, what other family members may potentially be able to be protected through you, so that you're not losing resources to your own cost of care and that could be potentially reserved. So with that, I'm going to just turn it over to Lynn for some final comments if you have any as a follow-up, and then we'll see what questions I can answer.
That I would just say, I don't really have any final closing other than just to say that it has been a lifeline to have the support of someone who can net all this very complicated stuff out, and to make it feel so much more like we do have a plan. And the scenarios, again, Gino and I had learned and continue to learn so much as we have stepped through this process that has felt very empowering and very compassionate in terms of like, there is help available. And so to step through the scary to a place of support is just what I would encourage all of us to do. Because I think I sat for a little while in the it's too complicated space until the first conversation that really made it feel much more like, oh, there's a lot to know, but I don't have to know it all. There's somebody who can help.
Right. And Lynn is one that needs to know everything, wants to know everything, and that it's very important. And other people, they just want to know what to do. And the thing that I would tell you is that you have to walk that journey of answering the questions to know what the range of options are that for your situation are going to be most appropriate. Anne, do you have any follow-up comments?